All right, so Mr. Dunn, you're here before the pardon board this afternoon because you submitted an application for clemency. You're asking for a commutation of your sentence, which you were sentenced to life November of 2002 for a second-degree murder convictions out of East Baton Rouge Parish. Is that information correct, sir?
Yes, ma'am.
All right, would you answer Mr. Wise's questions?
Well, you know, as I was going over your record there, how long you been incarcerated?
Right at 20 years. March 5th will make 20 years exactly.
20 years. You know, you have some opposition, law enforcement opposition is against your release. And also we have victims opposition, which is against your release. Some of the programs you've taken, I've looked at some of your programs there. I want to ask you, and you were arrested on 3/6/2001 by East Baton Rouge Sheriff's Office on the offense of manslaughter. Then on 8/7/02, you were found guilty of second-degree murder. Is that the way it went down?
Yes, sir.
But you were first charged with manslaughter, right?
Yes, sir.
Did you plead guilty to this, or did it go before a jury?
It went for a jury, sir.
You were found guilty before a jury.
Yes, sir.
Some of the programs you've taken, have, like anger management. Have you taken anger management?
Excuse me, sir. Did I take? Yes, sir. I took the
Have
course.
you taken anger management?
Yes, sir.
I see you've taken some welding. You've took some welding classes, and you've took some victim awareness, restitution, money replacement, living in balance phase 1 and phase 2. Where are you housed at down there in Angola?
On the East Yard, the main prison complex.
Are you a trustee?
Yes, sir. I'm a Class A.
What do you do?
I work in the library.
How long you been a Class A trustee?
I think for probably going on about 2 or 3 years. I've been a trustee since 2015. I started off as B class. I think I've been A probably about 2, maybe 3 years.
Okay. Well, thank you. I don't have any other questions.
Thank you.
Thank you, Mr. Wise. Mr. Roche?
Thank you, Madam Chairman. Mr. Dunn, good afternoon. How are you?
I'm well, thank you.
Okay, the crime was committed on March 6, 2001. Am I correct?
Yes, sir.
And so you've been incarcerated for less than 20 years.
Probably, within probably with a week or so, it'll be 20 exactly.
But it's less than 20 years as of today. Am I
As
correct?
today, you're correct, sir.
Okay. Now, the original charge was manslaughter, as Mr. Wise said. Am I correct?
Yes, sir.
And the jury saw enough evidence to render a decision of second-degree murder. Is that correct?
Yes, sir.
Is it possible, after hearing from the 5 eyewitnesses that contradicted your version of the events, that the jury came to this conclusion?
Yes, sir.
Because there were 5 eyewitnesses in their drive-in and surrounding areas, and one couple in particular that was immediately behind the car that you were in told the exact same story, separate from each other on 2 different occasions, and say that you were the aggressor. Is that not true?
Yes, sir.
So why would you pen such a statement when you submitted the application that the young man came up and you were in a tussle? You thought it was reaching for a gun, so you just happened to have a gun and you pulled your gun and it went off accidentally as you were in the tussle.
No, I relayed what I said in the statement is what happened. That was
Okay. As Mr. Wise says that you have opposition, I want to let you know this opposition comes from the entire legal community, the judge, the district attorney's office, the sheriff's office, and the chief of police. You also have very strong and adamant opposition from your victim's family. And basically, in my opinion, Mr. Dunn, and I'm going to be very frank with you this afternoon, 20 years on a second-degree murder charge is totally insufficient time for taking another human being's life. And I just want to enter that into the record because basically that is my opinion, and I think it's a little early on in the process for you to receive any clemency. Madam Chairman?
Thank you, Mr. Roche. Mr. Marabella?
Thank you, Madam Chairman. Mr. Dunn, how old were you when this happened?
I was 24, sir.
Okay. Now, you know, it's not our job to rehash the facts of the case, but I am interested in what happened. It's my understanding you were in your car
Yes, sir.
when this man walked up to you.
Yes, sir.
Did you know this man at all?
No, sir. I've never seen him before in my life.
Why did you have a gun?
For protection. The gun was in my name. I had papers on it. It was for protection.
Now, I'm not sure exactly what your position is because I really didn't understand it from what you told Mr. Roche. But your position has been, as I've read it throughout this thing, that it was self-defense. I mean, at one point you said you fired one shot at him and then you fired 2 or 3 shots in the air as he ran away, when in fact, this man was shot 4 times laying on the ground. That's what the autopsy said. That's what the witnesses say. Now, what happened?
We was in a tussle. I had never shot it was 3 shots fired. It was close range and the gun went off while we was tussling. While we was tussling, I never shot the man on the ground. I never stood over him. All the gunshots was while we was tussling. We was in a struggle. I did fire the gun when he ran away. Up until that point, I never seen Mr. Broussard in my life. But that first time when I was in the drive-thru, we was in the Turkish drive-thru, I was on the passenger side of the car. He came and knocked up on the window. I rolled the window down. He leaned in the car. He said, "Are you stealing from me? Are you stealing from me?" I told him no. I said, "Man, I don't even know what you're talking about." I told him to leave the car. When he bagged up, I had stepped out the car. I closed the door. I turned around and closed the door, and he grabbed me. From that point on, we went to tussling. When he reached on me, I came up with the gun. I had a gun on. And that's what happened, sir.
All right. Now, how are you a changed person from the time this happened or not?
Okay, from that time to this time, I think better. I'm no longer the individual that was there that night. I've been taking my time to learn me, to get a better understanding of me. And I've learned that sometimes it's not good to act on repulse. I know the time right now, I didn't took anger management classes. I didn't take classes that help me that sometimes you just got to take a breath. You got to step back and you got to think about the consequences of your actions. You got to see, is this situation, do you have room for you to be able to walk away? Do you have enough time to just try to avoid the situation altogether?
Well, let's go back 20 years ago.
Yes, sir.
The guy knocks on your window. What would you do?
Now?
Yeah.
When once I'd have told him I didn't understand, I didn't know what he was talking about, I'd have never got
Weren't
out.
you inside your car?
Yes, sir. I'd have never got out that car.
You could have rolled up your windows, locked your door. You didn't do any of those things. You got out to confront him.
At that time, I was immature. Now, with everything that I learned over my time being incarcerated, I know I should have never got out that car. If I could do that today, I would never have got out that car. All this stemmed from me getting out that car. This whole situation stemmed from me getting out the car. I'd have never got out that car. I'd have just rolled the window back up, and that'd have been that.
You know, I guess what bothers me about the facts of this case
Yes, sir.
is what your position still today is. When a jury has heard this case and listened to you and listened to all of the witnesses and decided that this was a second-degree murder as opposed to a manslaughter or any sort of self-defense case.
Excuse me, sir. I'm not trying to argue with none of that. I take full responsibility for my actions. I'm not trying to make no defense of nothing. They found me guilty. I understand that.
Well, what I'm saying is, I don't believe the jury found you guilty of what you said you did. That jury found you guilty of firing 4 shots into a guy who was helpless. And that's what you're not accepting responsibility for.
I am, sir. It's my fault. I take full responsibility for this being my fault. I know if I'd have never got out that car, we would never be sitting right here right now. There's no way around it. All these actions fell on me. Somebody lost their life behind a poor decision I made. I should have never got out that car. I accept full responsibility because this ain't on nobody but me. I can't put the blame on nobody but me. This is my actions. I regret it till this day.
I do appreciate your comments and I appreciate your accepting that responsibility. Thank you. That's all the questions I have. Thank you.
Thank you, Mr. Marabella. Mr. Wise? I'm sorry, Mr. Jones.
Yes, not to rehash all what's been already said. What was going on prior to all this? Why did you feel like you had to have a gun in your possession? Had you ever been arrested before prior to this?
No, sir.
Any drug, alcohol use, or
No, sir.
no drug use, no nothing? But you felt as though you needed to have a weapon for your protection.
I was robbed when I was like 17 years old, sir. I just had a gun for my protection. It wasn't nothing. I wasn't into anything. I wasn't that. I felt that my life was in danger on a daily basis.
Yeah.
I was robbed at one point in my life when I was younger. And around that time, I just started having a gun for protection.
Well, that explains it. I was wondering why you thought that you needed to be carrying a weapon, especially having it on your person. Because if I'm hearing it right, you had it on your person when you exited the car, right?
Yes, sir.
Okay. And you didn't know this guy from nobody, and why would he accuse you of stealing?
Sir, I've racked my brain for that.
Yeah.
This whole time, I don't know. If any, Mr. Paul was coming from my understanding, Mr. Paul was on his way from a junior college in Mississippi, on his way home to Texas. I've never seen Mr. Paul in my life. I never came across him. The first time I ever seen Mr. Paul was when he knocked on the window. That was it. I didn't have nothing against Mr. Paul. I didn't know him.
I don't have any other questions.
Thank you, Mr. Jones. Mr. Dunn, what's your level of education?
I have a GED, ma'am.
Did you get that since you've been in jail, or did you already have that?
I had my GED before I got incarcerated. I got my my GED at Gulfport Job Corps.
Good. So what grade did you finish in school?
I guess the 11th, ma'am.
Why'd you quit?
Really, I wound up moving to California with my stepfather for a time. And while I was there, my grades wasn't the best. And so I kind of just left school, and then I came back home and I went to Job Corps and I got my GED. My mother asked me, she just wanted me to finish my education. So I went to Job Corps and I got my GED, ma'am.
Well, good. All right. I don't have any other questions. We'd like to hear from whichever warden would like to comment about Mr. Dunn.
This is Warden Lamar here. I don't personally know Mr. Dunn. I can just go by his record. He does have a good record. He has been a Class A trustee since 2018, working in the library, and he only has 11 DB reports. So that's, so far since he's been incarcerated, that is really, really good. So that's really all I can say at the time.
All right. Thank you, Warden LaMartiniere. We'd like to hear from family who've indicated they'd like to speak. Let's start with Miss Tammy Scott.
Good afternoon.
Good afternoon.
I really would like my brother to be home. It should have been a self-defense case. I don't want to rehash all that what happened, but everything that was said about Mr. Broussard, where he was going, what he was doing was not the truth. His trial was not fair. But my brother has, repented about what had happened. He didn't try to run when it happened. He called and he said, "Can you come and take me to turn myself in?" He didn't want to take that person's life. It's hard. He's my only brother. I have 3 kids. I've been through cancer. My daughter has never seen him out of jail. He was a good uncle to my boy. I'm just heartbroken that he has done some time. And I want him home. I think he deserved to be home. And I understand that the Broussards lost somebody. I am very sorry. I mean, if there was anything that I could have done to make sure that nothing would have ever happened to anybody, I would have done that. It's just, I guess, the wrong place, wrong time. I'm very sorry for they lost. Mom, I cannot talk.
Madam Chairman.
Thank you, Ms. Scott. Thank you, Mr. Roche. We do appreciate you sharing your remarks with us this afternoon. I think, can we hear from the Broussard family now? Miss Linda? I'm sorry, ma'am. Would you unmute your microphone?
My brother Cedric is speaking for me.
Okay, good. Mr. Whitfield.
Did he come on? Is he there?
I don't think so. Is he there with you?
No, he's in Fort Worth, Texas. I'm in Houston, Texas. Do you want to speak from? Well, I'll speak.
Okay.
I think I can't. I haven't heard my son's voice in 20 years. I don't think he should be out. When I can't see why should his mother see him when I can't never see my son again? He got life with no possible chance of parole, and life with no possible chance of parole means life with no possible chance of parole. I don't understand how he can come just because he was a good citizen in prison. That don't mean he's gonna be good when he get out of there.
All right, I think Ms. Linda?
I'm sorry. Yes, I'm sorry. Another call came through. I'm sorry. But she said his sister said things didn't go right in trial. It was right. My son was coming from Mississippi State, from college. He was making something out of his life. He could have went to any college in the country, but he chose Mississippi. He would have been number round pick. He already had scouts looking at him in college. And he took all that away from us. And he took my son's life. And I don't think he got a niece and a sister. He was my only son. And I don't think he should be out of there. I don't want to cry, but he shouldn't be out of there. That's all I got to say.
Thank you, Ms. Broussard. We appreciate you. We appreciate you sharing your thoughts. Can we hear from the DA's office from the 19th, Mr. Danielson?
Yes, ma'am. So I was the trial attorney on this case back in 2002 or 3, I think. I think it was like maybe 18 months or so after the arrest. And I believe that we gave Mr. Dunn a fair trial. I would note that there's a published decision from the First Circuit Court of Appeals that kind of lays out some of the facts. I won't belabor any of those, but we came out with a unanimous verdict. Mr. Dunn had the opportunity and took advantage of the opportunity to testify on his own behalf. The gentleman that was driving the car that he was a passenger in, Mr. Davis, he took the opportunity to testify on behalf of Mr. Dunn. The eyewitnesses that were in the motor vehicle directly behind the car that Mr. Dunn was in, who were totally unrelated to anybody in the case, they testified, and they testified that Paul James Broussard Jr. Approached the car and knocked on the passenger window, but did nothing aggressive, did not have a weapon. Mr. Dunn opted on, regardless of why he had the gun on his person then, he rolled down the window, and the conversation was described by the people behind that car as amicable. Mr. Dunn chose to exit the vehicle. He chose to shut the door. There was no tussle observed by any of the eyewitnesses. And then at some point, Mr. Dunn discharged his firearm at least 4 times. There were 4 shell cases that were recovered at the scene. Mr. Dunn fled the scene initially. He ran. He did not stay and report it. There were other people that were in danger by Mr. Dunn's discharging that weapon. And Mr. Broussard was shot, I think, in the front of his right armpit, to the right chest, and to his mouth. He was unarmed. This was totally senseless. It never needed to happen. But the defense had the opportunity to present their claim of self-defense. The jury heard it. The jury unanimously rejected it. The jury found him guilty of second-degree murder. And I think we gave Mr. Dunn a fair trial in this case.
Thank you, Mr. Danielson. We appreciate the DA's office input as always. Mr. Dunn, is there a statement you'd like to make before we reach a decision?
Yes, ma'am. First, I would like to thank the board and the members for giving me this opportunity. Once again, I would love to apologize to Paul Broussard's family. I understand your son is no longer here, and it's my fault. If I could do it again, I would. I understand I should never got out that car. Me getting out that car is the reason we're here today. I'm sorry. I regret it. I never meant for it to happen. It was not. It was unforeseen and it was my fault. At the end of the day, I took a life and I regret that. And I regret that. I mean, it's a loss and I can never get that mother back her child. And it weighs on me and I regret it. And I just like to apologize to the Broussard family. I'm sorry, man, Miss Linda. If I could do it over again, I would never get off the call. I'm sorry.
Thank you, Mr. Dunn. We appreciate your statement. Mr. Wise, you ready to vote? Turn your, you're on mute.
Get back used to that. Today I'm gonna be voting to deny this application. One thing I think you need to be working on some more programs, and there's opposition, very strong opposition against this relief. You spent 20 years. I'm telling you, you're real close. Just keep doing what's right. That's my vote.
Mr. Roche?
Excuse me, Madam Chairman, my vote is the same, for the same reasons.
Mr. Marabella?
Thank you, Madam Chairman. Mr. Dunn, it looks like you're doing pretty well in prison. You know, we rehashed the facts of the case today, and I'm not going to belabor that again. We've all talked about that today. I do accept the fact that you've accepted responsibility, but you know, when you say, I would have never gotten out of that car, I wouldn't do it again, you're not in prison because you got out of that car. You're in prison because you shot a man 4 times and you killed him. That's what got you in prison. Not the fact that you got out to talk to him. The fact that you got out and you shot him 4 times is why you're in prison. I hope that you continue to work hard and try to accomplish some things in prison. You were sentenced to life imprisonment. 20 years is a long time, but that's certainly not enough time as far as I'm concerned for what you did and for what you have yet to accomplish. So I'm going to encourage you to continue to do the things you're doing. And the next time you come before the board, I want you to think a little more about what you actually did. It seems to me that you're not accepting responsibility for the fact that you put 4 bullets in a man. It's more than just getting out of that car and arguing. You had a gun, you discharged it 4 times into a man's body and you killed him. My vote today is to deny.
Mr. Jones?
Mr. Dunn, you find yourself in a real bad position here, and all I can do is encourage you to make the best out of a bad situation. Yep, I know you regret getting out of that car that day. I don't know what prompted you. If you were the passenger on the seat, I don't know what prompted that. I don't know if you were trying to prove your manhood or what it was or what was going on that day. But that was a bad mistake getting out of the vehicle. Continue doing the work that you're doing. Continue, but my vote today is gonna be to deny also, and wish you all the best.
So, Mr. Dunn, I do concur with my colleagues on everything that's been said. My vote today also is to deny for the reasons stated, and with encouragement that you can, continue to work hard, reapply when you're eligible to do so. Good luck to you, sir.
It is just a tragic, tragic death, a tragic waste of, as the mother was stating, he's coming out of high school as not a draft pick, but as joining Mississippi College for football. I mean, a top school. He's got his whole life ahead of him, all of that great potential, and only to be taken down in the most brutal senseless way. And then to have, and it's, we'll go over this little article and then also the court records, because I'm sure you might be curious about those records and say, okay, was it self-defense? Was it something different? But I was annoyed and irritated how he kept on saying, I shouldn't have gotten out of that car. That was my mistake. His sister gets on and says, he was in the wrong place at the wrong time. It was a manslaughter case. And we always so often see this in these cases where the ones who are speaking on behalf of the convicted, of the felon, of the person seeking the deal, they say, they have like these rambling, selfish type statements. They start crying and they say things that are just so insensitive. It makes you wonder, to say things like, and he missed this, and he missed that. And it's like, their mother is on the other line watching this. He took her son's life. There was a jury trial that said you senselessly killed a man who didn't have a weapon. And then you just keep on saying they were wrong. The jury was wrong. It was this noise in the background. Hold on. There's always a load in the laundry. And that's just, I think, how it is when you have a family of 5. So, and then it's just like throwing dirt in the face of the victims by saying things like that. And it never ceases to amaze me, but we see it so often. So, and this was so tragic. It happened with his father. It's a father and son just going through a truck through a drive-through. Funeral services are being held for the high school football player who was shot and killed this week in Louisiana. So police in Baker, just north of Baton Rouge, are trying to determine the motive of the slaying from a Baton Rouge man in jail charged with manslaughter. So Broussard, who was 21, was shot in the parking lot of Church's Fried Chicken restaurant where he and his father had stopped to eat. Baker Police Lieutenant Allman said Paul Broussard Sr., a truck driver, had parked his 18-wheeler at the fast food restaurant and gone inside while his son stayed in the truck sleeper. So if you can imagine the terror of being a proud father of your college-bound son, all those years that you invested in him going to Pee-wee football and sticking through it and showing up to his games, and he gets that letter where he's getting accepted to Mississippi, and then right before the college year starts, you stop at a truck stop on your route. You're doing a father-son trip together, and your son is murdered. And he would have had to have seen that. He would have had to have held his son in his hands. So when he was inside getting the food, the younger Broussard got out of the truck and approached the car in the restaurant's drive-through lane. After talking to a passenger in the car, the driver of the car got out and fired several shots. The victim, who was expected to play football at Mississippi State University that fall, died at a local hospital. So now let's go to the details of the appeal. And on that note, to have a district attorney show up who actually tried the case, that's very rare. We've seen it a few times. I mean, just to have a DA show up is rare, right? But to have one show up that actually tried the case, thank you for being there on behalf of the victim. On May 6, 2001, the victim, Paul Broussard Jr., was shot to death outside the Church's Chicken on Main Street in Baker, Louisiana. He suffered gunshot wounds to the front of his armpit, to the right of his chest, and to his mouth. The victim had no contusions or scratches on any other part of his body. Prior to approaching the defendant, the victim had been sleeping in an 18-wheeler parked at Church's at Church's. 4 .38 caliber bullet casings were discovered at the crime scene, but no weapon were recovered from the crime scene. The .38 caliber weapon used to kill the victim was retrieved from the defendant's uncle. The victim was approximately 6'1" tall and weighed 260. I mean, this is a football player. No ethyl alcohol was detected in his blood. So he's not drunk. However, his urine determined to contain a metabolite of marijuana. I don't know what a metabolite is. Sounds like a little, and the defendant was approximately 5'10" and weighed 245. He's not a small guy either. Okay, 245 and 260. So it's not like he even at 260 was at a huge advantage over the guy with the gun. Which, like, that's quite interesting, right? The state presented testimony at trial from the occupant. There's one thing if you're 260 and then the other guy's like 180. There's a lot of things that can be going through. Yeah, you never get out of the car. You definitely don't get out of the car when you're concealed carrying a weapon. It's your job to de-escalate. It's your job to avoid ever getting out of the car, in my opinion. But even I'm just saying is that they're both they can both handle themselves. The state presented testimony at trial from the occupant of the vehicle that was waiting in line and the defendant's vehicle at the time of the incident. John was the passenger in the vehicle. He saw the victim walking over to the defendant's vehicle and began. So these are now the witnesses that they were talking about, right? He saw the victim walk over to the defendant's vehicle and begin talking to the defendant. Lockhart thought the victim and the defendant knew each other because the defendant rolled down his window to talk to the victim. The defendant and the victim spoke to one another, and the victim, steady, had a smile on his face. Thereafter, the victim moved back from the car, and the defendant exited the vehicle. Lockhart turned away to look for change to pay for his food, but looked back at the men after Lockhart's wife alerted him to the fact that the defendant had a gun. So this is the eyewitness. He sees everything happening. Then he turns because he's in the drive-thru lane to pay for the food. The wife says he has a gun. He looks back. After seeing the defendant retrieve a pistol from under his shirt, Lockhart told his wife, who was driving, to quickly get out of the line. Lockhart then heard gunfire and took cover, but saw the victim turn around like he was trying to get away from there to run. The defendant fired at the victim again and was steady shooting the victim. Lockhart saw or heard approximately 5 or 6 shots. Lockhart never saw the victim pull a gun on the defendant or hit the defendant. So that's one. Now here's another eyewitness testimony. Donna Heel was the driver of the vehicle behind the defendant's vehicle at the time of the incident. Heel testified she saw the victim walk to the defendant's vehicle from an 18-wheeler parked at Church's and talk to the defendant after the defendant rolled down his window. He was positive the victim did not approach the defendant in an aggressive or mad manner and indicated the victim and the defendant spoke like they knew each other. After the men spoke for a short time, the defendant exited the sorry, I had to double check my mic was on. I get like PTSD that my mic is for some reason not on. The men spoke after Heel pulled the victim to the defendant's shirt. Heel noticed the defendant had a black pistol on his side. Heel saw the defendant shoot the victim when the men were very close to each other. Following the first shot, the victim moved back, but the defendant continued shooting the victim. When he asked if she had seen the victim move like he had a gun, Heel indicated the victim did not have a gun. Heel stated that she did not see the victim punch or hit the defendant. Moreover, from what she observed, Hale indicated that it did not appear the defendant was acting in self-defense when he shot the victim. The state also presented testimony at trial from Shirley McDaniel. McDaniel was taking orders from the drive-through line at Church's at the time of the incident. While taking a young man's order, she heard, "You heard me, mother effer," followed by gunfire. The cursing was not directed at McDaniel. McDaniel conceded she could not tell if the person who cursed was the same person who was placing the order or whether the person who cursed was the same person who opened fire. I mean, can you imagine in broad daylight just being like, you know what, I'm just going to go, like, You know, the way the story was told at this hearing, I did not envision it being in a drive-through of a restaurant. Like, I just envisioned it as being like he was in, you know, outside someone's house, maybe in the wrong place, and there was. But this is totally uncalled for. I mean, this is a public drive-through restaurant. In the middle of the day. It's just so ridiculous. Did it say what time it was? I don't think it says what time. The defendant testified at trial. He gave the following account of the incident. While he was the passenger in a vehicle driven by Davis waiting in the drive-through line at Church's, the victim tapped on the passenger side window. The defendant rolled down his window, and the victim leaned on the window, stating, "You stealing from me? You stealing from me?" The defendant asked the victim what he was talking about and told the victim the defendant did not even know the victim. The defendant then exited the vehicle holding his hamburger in one hand and was immediately grabbed by both shoulders by the victim. The defendant got away from the victim briefly, but was then grabbed from behind by the victim and pinned against the car. The victim told the defendant, "Any move you make, I got you. Anything you do, I got you." The victim then reached on the defendant. The defendant drew his weapon, and the victim grabbed the weapon. I love how his story's just completely different from what we just read from the eye testimony. In the ensuing struggle for the weapon discharged. The defendant claimed the victim hit him in the mouth during the struggle and tore his t-shirt. The defendant conceded he carried a gun, he always wore a bandana, and he had tattoos on his body stating Graveyard Soldier, RIP, and HGC, which meant hustling to get cream. I don't know if those are gang things or not. I have no idea. But yeah, two very different stories, of course. Davis also testified at trial for the defense. Davis conceded he was the defendant's close friend and considered him a cousin. Davis gave the following account of the incident. Davis pulled up to the speaker at Church's on the night of the incident and placed his order. The victim knocked on the passenger window and the defendant rolled down the window. The victim accused the defendant of stealing from the victim. The defendant told it's just a ridiculous story anyways. Like, what do you mean you stole? Like, you're gonna you don't know, you stole from me. The defendant told the victim the defendant did not know the victim and did not know what the victim was talking about. The victim again accused the defendant of stealing, and the defendant exited the vehicle. The victim brazened up on the defendant. I mean, here's someone from Mississippi. It's not local. It's impossible for them to accuse him of stealing anything. Why did he walk up to the door, and what did he say? That is interesting, you know? I wonder if we'll ever know. We may never know. The victim again accused the defendant of stealing, and the defendant exited the vehicle. The victim brazened up, and the defendant continued to accuse him. I mean, why would a man ever go to another stranger's car and start trying to talk to them? But kids do stupid things. The defendant continued to deny stealing, and while going into the victim's pocket, the victim grabbed the defendant on the shoulder, telling the defendant, "I got you." A scuffle ensued, and the defendant broke free from the victim. Davis closed the defendant's door and was about to open his door when gunfire erupted. Davis drove off because he did not know who was shooting. He saw the victim running, and he did not see the defendant. Thereafter, Davis saw the defendant running and stopped to give him a ride. Davis claimed the entire incident lasted a couple of seconds, and the victim was attacking the defendant during the incident. The assignment of error. Number 2, the defendant contends evidence was insufficient to prove the second degree. So, you know, what this does come down to is the, I guess, 3 eyewitness testimony versus his account and then his best friend's account. And who the jury's going to find credible. The bottom line is you have two men, one with a gun, one without, and one man ends up dead. The crime of second degree is killing a human being. Okay. I mean, they don't talk about how like he was on the floor shooting down at him, which I think one of the judges mentioned. But, you know, the problem of getting a carry license when you're very young and full of vinegar is that you're very young and full of vinegar. When you carry, you have an extra responsibility to stay out of trouble. I'm trying to see if they're bringing anything else. Can you just imagine his whole life ahead of him, getting a college scholarship to Mississippi to play football, and before your season starts, your life is taken over absolutely nothing? And, you know, part of his story is he claimed that he, you know, his sister claimed that he had stuck around, and that wasn't true. They said he had left. And to just stick to it, my fault was getting out of the car. He was in the wrong place at the wrong time. It's like, no, you killed a kid. No, he's a man, but I don't see where they'd say anything else here. Thank you, Richard, for dropping those links. Then they say it was an excessive sentence. You know, I mean, there's out of the hundreds of crimes that we cover in Louisiana, this is not nearly as, you know, the worst. It was really just like done out of, it's just senseless. You know, should it be a life sentence? That's compared to other crimes, I think that you might argue no. But definitely more than 20 years. His story just made no sense. You stole from me, then he came up, then he, you know, and then he felt like he was being attacked, but then he shot him a bunch of times. A thorough review of the record shows that there's no reason for trial to deviate the mandatory sentence provided. The defendant failed to clearly and convincingly show that because of unusual circumstances, victims of the failure to assign sentence, gravity of the offense, the defendant shot the victim to death and endangered the lives of numerous people present at the crime scene, including at least one child present in the vehicle behind the defendant's vehicle during the shooting. The assignment of error was without merit. So that was it. You know, for him to, maybe he believes that he was being attacked at this point, but that's not what he has to. That's not going to get you paroled. To say, all I did was get out of the car. Shouldn't have gotten out of the car. And you're going to have beef with someone? Go use your fists. You're both big dudes. I mean, imagine being 5'10", 245 and feeling that you need to use a handgun. Anyways, that's it. I'll put the links in the description. And with that, I'll let you go.